Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Interpretation class. In this video, we are going to discuss the taxing statutes. And please remember, whenever there is a taxing statute, it should be strictly construed. Strict construction should be there. There is no liberal construction. Before that, let us know what is tax. Tax is the amount collected from the so-called persons who take the services of the government and earn money. The tax is collected for the public purpose. And when once a person comes within the ambit of the taxation, he has to pay, that's all. There is no other go for him. He cannot take exemptions. Already the government has given lot of exemptions. Suppose if your annual income is more than 8 lakhs or 7 lakhs, then only you will come under the purview of the so-called taxation. So taxation laws should be strictly construed. There is no chance for personal discretion. This you have to remember. Tax is imposed for raising the revenue of the state, so for public purposes. Tax is imposed for services rendered by the state, maybe the state or central. For example, goods and services tax, value added tax, central sales tax, and likewise commercial taxes of AP. Excise duty, customs, so many taxes are there. They should be strictly construed. This is what you have to learn. Taxing statute is a statute which makes a compulsory imposition of the tax or compulsory imposition of the fee. Right. So the central government is competent, under Schedule 7. There are 3 types of subjects: union list, state list and concurrent list. So as per union list, central government has got the authority to impose the tax, central tax. List 2 is state tax. Right. So taxing statute should be strictly construed. In the beginning I told, if a person comes within the tax permit of law, within the power of law, he should be taxed. That's all. There is no other go for him. So, and the taxing statutes, they have got the binding authority. There is no lenience. Right. So please remember, there are 3 points here you have to write. Number 1, the taxing statutes cannot be interpreted or any presumption or assumption. For example, in the golden rule of interpretation or in some other rules of interpretation, I told you may become shall and shall become may. Here there is no chance of may. Shall means shall, that's all. I am going to discuss a case law, very recently decided case law by the Honorable Supreme Court in the next video. You please see that also. Before taxing, it must be shown that he falls within the ambit of the particular section. That his annual income is like this, his household income is like this, the revenues like this. So you have to show him the cause. If the words are ambiguous, please remember, the benefit should go to the taxation law, not to the other person. Right. So case laws we are going to discuss. The first case law is J. Srinivas Rao versus Government of AP, decided in 2006. In this case, the court cannot imply anything which is not expressed. In other rules of interpretation, you can draw it. Mischief, what is the mischief in it? How to rectify the mischief? But here, please remember, court cannot imply anything which is not expressed. So, it is assumed deficiency. Then the court has only to decide. So, taxing statute should be interpreted in a strict construction way. Second case law, Shabina Abraham. Shabina Abraham versus Commissioner, Central Excise and Customs, 2015. So please remember, by unnatural and unreasonable extensions, a taxing statutes can be made applicable to a citizen. It should be strictly imposed. That's all. There is no other goal. So, as far as the taxing statutes are concerned, you must be aware that they have to be given the strict construction, no liberal construction. Okay, I hope you understood it. With this, I am concluding. Thank you.